Welcome. This is a Stepping Stone series. Pete Carter, Land Grab. Interview by Caroline Stevens. Over to you, Caroline.
Welcome to a Stepping Stones interview. I'm Caroline Stevens. Today I'm welcoming Pete Carter. He's based in Derbyshire. Hello, Pete. You've got a very interesting company name. Now, is it Tunkishila or Tunkishila? Can you explain what it's all about and your story about the law and the land grab? Over to you, Pete.
A little bit of background first on myself. I was project manager back in 2010 and 11. I had two companies as well in the IT business, but I was a project manager for telecoms and engineering. I left that due to a family issue where I first had experience of Her Majesty's Courts and Tribunal Services. Are we okay? I've lost sound, I think. Have you?
You're fine.
You're all right, yeah. So yeah, that gave me the first experience of the court system, and then after that, there was other issues. Basically, I ended up having to take the Secretary of State for Work and Pension to court over unlawful deductions for Child Support Agency, where I had a shared residence order for my child. But the Secretary of State had classified me as a absent father and a non-resident parent, and had been deducting unlawfully large sums by way of a deductions of earnings order, where there was no hearing or anything like that. It was just basically faxed over to my employer arbitrarily, you might say, which led me to a sort of 2.5-year battle in courts in Manchester, then into the High Courts, and then over into the Royal Courts of Justice, where the state basically cheat and you know, all kinds of, you know,
Pete,
we could go into.
Can you just explain, when you say it's been passed from court to court?
Yeah.
Was it a case of they stipulated how much you had to pay, but you had a dispute over the physical amount?
No, absolutely not. So basically, I had a shared residence order. Back then, they were called shared residence orders under the Children's Act of 1989. A shared residence order was an order settling the arrangements of where a child is to live. So clearly, the child lived with me for half of a week, basically.
Yeah.
And he lived with mum in a different household for half of a week. Now, the issue became about because although the Child Support Act 91 recognised that there could be two persons with care, the Secretary of State for Work and Pension and the Child Support Agency did not recognise that there could be two persons with care, and automatically assumed that one parent must be what they called an absent parent or a non-resident parent. Basically, you know, like I say, that their decision to classify me as a non-resident parent or absent parent was arbitrarily made. There was no notices served, there was no court hearing, there was no tribunal hearing. They simply received instructions from my ex-partner and the child's mother to proceed with a case against me. And what they did was simply just fax over to my employer basically a very loose piece of paper that basically gave an amount that they wished to collect from my wages. And my employer started deducting at source without any court or tribunal hearing at all.
Wow.
Large sums of money from my earnings. So at one point, well, for a considerable period of time, I was working 60 hours a week, and I was coming home with a net pay of £454 and 54 pence. And you know, yeah, it was absolutely shocking, to be honest. But you know, ultimately, like I say, it was a 3-year battle at court, Manchester Court, then into the High Court. There was a very nice judge at Manchester High Court eventually, called His Honour Judge Armitage QC, and he's retired now. But he gave me that opportunity to appeal it based on the human rights violations that I was arguing from the beginning. Which was successful. Their barrister, the Secretary of State, sent a barrister from Landmark Chambers, and it was a female lady, and she couldn't even address His Honour Judge Armitage QC that particular day. She asked him if she could remain sat down because she literally couldn't stand to address him, following my half a day legal arguments, basically. I'd obviously spent a considerable amount of time on the legal arguments.
Presumably, you spent a lot of money as well.
Well, I did everything myself. I had to learn it all myself. Particularly, didn't spend a lot of money apart from time and energy and resources. I did initially have solicitors acting for me, but then I ended up sacking the solicitors because it was quickly apparent that they were taking, again, large amounts of money out of what I was earning and providing very little by the way of they were just dragging it out, basically.
Yeah.
Dragging it out and taking their time. And obviously, I was on a payment plan, monthly payment plan with them. So, for a whole year, basically nothing really happened. So in the end, I just decided to go alone and do it myself, basically. So. Interestingly, though, I technically lost that case on paper. I shouldn't have lost that case on paper. In fact, the Secretary of State had no rebuttal or argument to any of the legal points and submissions that I made. And the court in Manchester High Court reserved judgment. 3 and 4 months later, I was still chasing up where the judgment was. And then His Honour Judge Armitage QC, before he retired, wrote to me, basically sent me a draft judgment advising me that for some unknown reason, somebody had been into his private chambers at the court and removed large parts of my bundle of evidence. And when he made the judgment, basically 3.5 months later, after the hearing that I just mentioned, parts of my bundle were missing, and he basically wrote it into the judgment that he made the judgment on the basis of what he had available to him, caveated by the fact that large parts of the bundle had disappeared and the claimant's evidence had disappeared.
But that's shocking, isn't it? I mean, that's theft of evidence and negligence.
It's negligence, it's theft. Obviously, nobody could give me a straight answer. Apparently, the only types of people that have access to a judge's chambers behind a court, obviously, the public certainly don't have access to them because they're coded doors everywhere. Would be people in the HMCTS and higher echelons of government.
Yeah.
It then went to an appeal to the Royal Courts of Justice, which was completely shocking. It was sent 3 times to the Royal Courts of Justice by way of special delivery, grey bags. Each time was signed for. Each time they were weighed with obviously the weight of the bundle that was in them. And in a nutshell, there was arguments with Civil Appeals Registry Office at the Royal Courts of Justice where they turn around and say, well, yeah, we've received something from you. We've got, we'll admit that we've signed for something, but we say it was a letter. It was only a cover letter that you sent. You haven't sent an appellant bundle to us. And you say, well, I clearly did. It was weighted. I tell you what, we'll send it again. So you'll send it again at the cost of £12 something by special delivery, Royal Mail, guaranteed before 1 next day.
Yeah.
They'll say they'll sign for it again. You'll get the proof that they've signed for it again, but then they'll argue with you that actually there's no appellant bundle here for the second time. So in the end, I had to photograph the bundle going into the grey bag with the postmistress in Warrington, in Cheshire, and the postmistress couldn't believe what was happening, and I actually sent the photographs to the Civil Registry Appeals Office on email. And the lady that we were corresponding with at the time, I basically threatened her with perversion of the courts of justice, and that I'd have to privately prosecute her if this disappeared again.
Yeah.
On that third time, they did accept it. They did put it through. But then what happened when I got to the hearing was the judge turned around and said, "Well, you're out of time. You've only got 14 days, and you're outside the time window. So blah blah blah." So that's my experience of the justice system. I've got many other stories about the justice system in terms of other cases that I took against Greater Manchester Police and all kinds of other stuff in the past. But in relation to what you're asking me about Tuncashila.
Yeah.
And
love and respect for the land.
Love and respect for the land, yeah. Now, Tuncashila was the name I decided to call the company that I set up. I set the company up in December of 2016 for the sole purpose of purchasing a legal estate or land over in Glossop in Derbyshire. The background to that event basically was in the month of November, I met a lady who had been evicted from her home previously by High Court Enforcement Group Limited, High Court Enforcement Group Limited, private company, who are acting under licence and authority from the Ministry of Justice and the Lord Chief Justice of the country to basically evict people from their homes and enforce High Court orders.
Now, when you say evict people from their homes, there'll be a lot of people at home now thinking, what do you mean by evicting people from their homes? Are we talking about tenancy arrangements? Are we talking about mortgage situations? People who've got freehold, they own the house?
So the usual kind of evictions that High Court Enforcement Group will carry out is your classic example where you've missed 3 payments on a mortgage. The lender, the bank, the mortgage provider has taken that person through a very quick process in what they call possession claim online, PCOL. And basically, once you've missed 3 payments, they'll put you through the PCOL system, which is an accelerated fast-track process. The mortgagor, the mortgagee, the bank, is always going to get an order for possession, and that's how the system works. There's not really any argument that you can run in a county statutory court during that PCOL process which would avoid a possession order being granted, unless you make an offer to clear the arrears and pay the outstanding amount.
So you've got a case. So basically, we're talking about cases where people have mortgages with the bank or the building society, and after 3 months of non-payment of their mortgage,
then the bank can go in and, well, in fact, legally, the bank can actually repossess a property on day 1 of a mortgage deed. If someone's purchased a property with a mortgage from a bank, legally and technically, the bank is also a legal proprietor of the charge, and therefore they have absolute right of possession and legally could actually take possession on day 1 without any arrears. But obviously, that would be very controversial for them to do so. So it tends to be the fact that they would only take possession, obviously, if you fall behind on arrears and if that bank has decided to take action to try and enforce its charge. Right. So that's your usual. This particular lady that we're talking about in Glossop in Derbyshire, a lady called Rekha Patel, she was actually evicted from her own property, which she paid for in full. So initially, when she purchased the property, she had spent, I think it was £167,000 on the property, and the property was in a vacant, derelict state. It had been derelict for some time. It needed remedial work and obviously substantial amount of work doing to it.
Now, Pete, if I remember rightly, this is a semi-detached property, isn't it? So it's attached to somebody else's property.
There's actually 2 properties that it's attached to. It's
right.
It's a middle. I think you'd call it a middle terrace cottage. With neighbours either side.
Yeah. Okay. Yeah. It's quite relevant, isn't it? Because for the outcome, I think.
Sure, yeah, exactly, yeah. So there's a neighbour on the left-hand side, and there's also a neighbour on the right-hand side. The neighbour on the left-hand side's got quite a small property, and the neighbour on the right-hand side has got a very large property with a lot of land.
So this is a case where there's no bank or building society involved in this. She owns it outright, and her name presumably appears on the land registry.
It would have done until we purchased the property from the people that we purchased the property from. So if I can, I'll briefly explain her position, okay?
Yeah.
Before I go on. So obviously, I didn't know the lady at all till much after she'd been evicted from an unfortunate situation that occurred in relation to her and a neighbour, okay? The neighbour who lives next door to the right-hand side took a claim against Rekha Patel for what she alleged was damage to architectural feature stones called thack stones that were damaged from her builders that was doing work on Rekha's property and Rekha's roof line. Okay.
Right.
And essentially what happened there was the neighbour next door said, look, I've got these architectural feature stones that protrude out from the gable end of my property. Your builder has cut through them, and I'm, now going to take a claim for, for damages as a result of that. Okay.
Okay.
Now, at the time, Rekha obviously was quite horrified by what she was, thinking. She immediately had the work stopped. She complied with because this is a Grade 2 listed building. They obviously the neighbour sent around a conservation officer and the council people in relation to the fact that it's a grade listed building, and perhaps she or a builder was alleged to have caused damage to stones. So she was complying with them. It turned out that actually the neighbour knew the conservation officer from the council, and basically they developed and hatched a plan to basically financially ruin Rekha Patel. Personally, having looked at this, I believe it's now, I didn't believe it at the time, but I do believe that it's now a racially motivated attack. They simply didn't want her living in the area, basically, from what I can gather, because the original story of the stones and whatever, it went to court in 2013 in the small claims court. The neighbour next door got a successful judgment in her favour, leaving basically the judgment was that Rekha Patel would pay £8,318.88 plus costs summarily assessed at £2,500. Now, Rekha obviously wasn't happy with that. She tried to appeal it in Manchester. She was flatly refused and given incorrect advice by the Judge Recorder Freeman at the time. And Recorder Freeman actually advised her that she was not entitled to appeal in the High Court at Manchester, and that she must go to London, which was incorrect. But nevertheless, obviously Rekha and the bad legal advice she'd had went to the Royal Courts of Justice in London to appeal the matter. At this time, Rekha has now been in contact with the person that sold the next door neighbour's house to the current person who had actually taken this claim against Rekha. He was a retired steeplejack builder with over 40 years experience in the building industry, working on Grade 2 listed and other listed kind of buildings in and around the Derbyshire High Peak area.
So where does this chap come into this? He bought one of the other houses?
He was the person that sold the next door neighbour the property in question, which she alleged the stones protruded from. Yeah.
Right.
So he basically turned around to Rekha and said, "Look, I've already had a visit from the lady who took you to court. Her name's Frances Briley. Yeah. I had a visit from Frances, and I'm going to tell you what I told her. There was never any stones protruding from the gable end of that property. He had all this English heritage information. He wrote a very well put together statement.
Oh, that's interesting then, isn't it?
Very interesting. And then it went to the London Royal Courts of Justice, where he was willing to testify on oath and evidence of the fact that he sold that property and that these stones never actually existed at all. And it was basically a fraudulent claim from the beginning.
Okay? Oh, gosh.
Obviously, the neighbour next door had a very comprehensive, what they call third-party litigation insurance. Now, third-party litigation insurance is what we call an emerging market. Since sort of 2014 on onwards, has been a very, very emerging, lucrative industry and market. Because of the cuts to legal aid, basically there is now private equity hedge funders and third-party litigation insurance companies that are willing to fund claims either on an individual basis or on what they call a grouped portfolio basis. Okay.
Yeah.
Now, this Frances Clare Briley had a very comprehensive package with, initially, against Rekha, it was a company called Duke Street Private Equity Hedge Funders. And after that...
are these like angels then, or are they...
Angels?
Yes.
How do you mean, sorry?
No, I'm just thinking they call them angels when they go into businesses. It's not like that, is it? It's just people out to make money.
Absolutely out to make money, yeah. And common law used to forbid what's called champity and maintenance. Because
sorry, what on maintenance?
Champity and maintenance.
Right. Okay.
Basically, if you were funding somebody else's litigation and you were seen to have control of that litigation, and therefore common law expressly sort of forbid that kind of activity, because it could lead to all kinds of unfavourable situations where the funder of that litigation is basically simply taking action to get what they call a return of the spoils.
Right, I get you.
Yeah. But now, with the fact that legal aid has pretty much all but disappeared, it has basically come back, and they've abolished the common law rules by repealing it with statutory instrument that repeals all of that stuff, and then obviously makes it okay. So there is a huge industry in third party litigation funding. It's several hundreds of billions and still climbing year on year. There's quite a lengthy amount of information online about it. If you look at harbour litigation funding and other reports that are in the public domain, you'll see just how lucrative that third party litigation funding industry is.
So this is a growing industry.
Oh, it's a hugely growing industry, because you can get a return on investment far bigger than any stocks, shares, bonds, or bank accounts can ever provide you with.
Yeah.
So it's 2,000% return on investment, as opposed to your average 8%, 6 to 8% in a high interest savings account.
Yeah.
Yeah. So that's that industry. Mentioned. Obviously, at this point, so she appeals it to the Royal Courts of Justice. Obviously, she's got structural surveyors, RICS qualified surveyors, expert witnesses, along with this previous owner of the property that actually sold the property to Francis Briley. They trundled down to the Royal Courts of Justice for an appeal, for permission to appeal. All gets aired, and essentially the court said, look, we don't understand why this evidence wasn't available to you, Recca, when you originally had the court trial. And the bottom line to that argument is that she simply wasn't aware of Graham and the person that sold this house, and she simply didn't have the information that, and she trusted the council and the conservation officer and all of these people who were telling her, look, your builders have damaged the property. So in hindsight,
these are supposed to be the experts. They're supposed to be working with you, not against you.
Well, yeah, but unfortunately not in this particular case. So she wrongly or naively trusted that the conservation officer was legitimate and genuine, and the people were obviously legitimate and genuine. Upshot was that the Royal Courts of Justice basically turned around and said, look, we can't allow this appeal to go forward. We're not going to give you permission to appeal. We're going to strike out the claim as wholly without merit, and that it has no merit at all. We think there's something untoward with the fact that this evidence has only just come out, and that's the end of it. You're simply trying to run the litigation and have a second bite of the cherry on this litigation, and it would be wholly unfair for the person who's already had a judgment in her favour to have to go through basically a second trial on all of the facts. Yeah.
So basically, this has gone against Recca then.
So that went against Recca, yeah. So that was 2014. Okay.
That doesn't seem fair, does it? That fact that these experts were not helpful.
Well, at the end of the day, you can see argument in both sides. That that there was a claim that was made. The claim was obviously heard at a trial, and then obviously after that point, new evidence has come to light that actually these stones didn't exist. I think the court feared, in my opinion, that had they given permission to appeal, there was absolutely no rebuttal that the neighbour who originally brought the claim could have actually provided to the evidence that was on the table.
Yeah.
Because it was that overwhelmingly strong. So in that, they basically turned around and said, look, we're going to just say no to the appeal. You're not having a second run of the litigation. It'd be unfair to this person to do so. Obviously unfair to the litigation insurance companies that were also funding all of that stuff. And basically said, look, you have to pay this amount of money. It's the original judgment stands £8,318.88. Plus now the costs have gone up. The costs were originally £2,500, but now they are summarily assessed at £8,500. So as a result of the fact that she went to the Royal Courts of Justice to do the appeal stage. Yeah.
Yep.
So that was just short of £17,000. Now, when I first met Recca, I was under the impression that she had not paid that amount of money. And when I first met her, having seen that she'd been evicted, I assumed that she simply couldn't afford to have paid the £17,500 and that the neighbour had took the property in order to try and realise that £17,500 and, that's why she'd been evicted. It transpired actually that she did pay Frances Briley. She paid just short of £17,000, which was in line with the Royal Courts of Justice order. She paid it in the March or April of 2014, and I've personally seen the Halifax cheque stubs and the Halifax bank statements showing the debit basically coming out of the account to Frances's lawyers at the time, which was Cogent Law. Okay.
This is the lady next door who still lives there, I assume.
She does still live there, yeah.
Yeah.
Yeah. So she was paid. She was paid in full. At the point that it was paid, obviously, because it was cost summarily assessed, that means that if you pay cost summarily assessed, that the matter is disposed of, and that Rekha Patel at the time she paid was no longer to be considered as what they call a judgment debtor, because payment had been paid to the judgment creditor.
So everything was settled, allegedly?
Everything was settled allegedly March or April 2014, correct? Yeah.
Yeah.
And then Rekha obviously noticed that there was still charging orders on her property following the fact that she had settled the matter. Yeah.
Yeah. Which would mean that she couldn't sell the property.
Yeah, or she did try and sell the property. Obviously, then a conveyancer would likely try and remove costs that were on there that obviously had already been paid.
Right. Okay.
So she applied back to the Manchester court, and she was successful in getting an order for the entries that were on that title register to be vacated forthwith, which means basically removed forthwith, immediately. Yeah.
Yeah.
Okay. So that happened. Unfortunately, the lawyers at Cogent Law didn't. It was their responsibility, and the judge said it was their responsibility to send that into the land registry because they were the person holding that charge. They had to discharge it from the land registry and send it in. Unfortunately, they didn't do that, and they left the charges on the property. And then several months after this event, they sent a threatening letter on letterhead. The court matters were done and dusted. They sent a threatening letter on Cogent Law letterheaded paper saying that they'd actually reviewed. They'd had their costs looked at by a cost draftsman, they called it, where they now believed that Rekha needed to submit £29,000 to their sort code and account number on the letter within, I think it was 14 or 21 days, or risk the consequences of going back to court. So this was a matter that had already been going on in court for 4 years. A matter that Rekha believed she'd completely settled by paying the £17,500 after losing in the Royal Courts of Justice and thinking she had no other option but to pay it. And then obviously out of the blue a letter comes through saying that you actually owe us £29,000 deposit in this sort code and account number. Obviously Rekha ignored it.
And this is is this from the solicitors or is this from
the solicitors for the neighbour? Yeah.
For the neighbour, okay.
Cogent Law, yeah. Not Rekha's solicitors, this is from the neighbour's solicitors, yeah. So the matter had already been dealt with, settled as far as Rekha was concerned, but then the neighbour's solicitors, several months after the event, decided that they were going to send a threatening letter to Rekha for sums of 29,000 and something pence, basically deposit it in this sort code and bank account number, which was written on the letterhead. By particular date by 4 p.m. If you don't, we'll take you back to court. Was the attitude of the letter? Yeah.
Yeah.
So Rekha just saw it as extortion, just as a way of trying to extort money from her, and just basically ignored it, knowing that she wasn't a judgment creditor, and she'd also applied to the Registry Trust Limited. Now, Registry Trust Limited are the registrar for all HMCTS county court judgments, fines, forfeitures, collection orders, that kind of thing, So any judgments or whatever that the court make, they are all submitted onto the Registry Trust Limited database, which is accessible online. And if you pay I think it's a small fee of £8 or £12, you can basically get a copy of whatever judgments and fines or forfeitures have been ordered against a particular person or a particular address. Okay.
Right.
Rekha applied for a copy of her own file from them, which showed that she was not a judgment debtor any longer, and that everything had been satisfied and removed from that register. Yeah.
Yep.
So she ignored the letter. Basically, what happened was
should she have responded? By the way, can I ask? Should she have written back and said that she wasn't aware that she should have paid any more money?
Do you know what? I can't answer for Rekha whether she did reply to the letter. I'm saying she ignored it. What I mean by that is she ignored it, and she didn't obviously. She didn't give in to the demand of £29,000. Yeah.
Okay.
I couldn't tell you actually whether or not Rekha responded to that letter directly to the legal to the neighbours' legal team or not. That's something we'd have to ask Rekha, to be fair.
Okay.
I can take an action to find that out.
Yeah.
But yeah, I mean, either way, as far as Rekha was concerned, and the paperwork that I've definitely had in my possession, the matter was concluded and it was settled, and there was no real grounds for them to go back for this alleged 29,000, because the time to do so was if they wanted a detailed cost assessment with a cost draftsman and all that kind of stuff, the time to do so is the minute that the court is giving summarily assessed costs. They then make an application and say, look, your summarily assessed costs at 8,500 are way out of line. We've got costs of the region of, I don't know, 29,000. So actually, we now need a cost judge to look at a detailed cost assessment of this. That's the way it should be done. They can't clearly come back to it many months after the event and start basically taking the piss, which is...
So basically, so if we fast forward to now, she's now, so to sum up, she's now out of her own property.
Yeah.
Of which she's paid, was it 170,000 originally?
170,000 plus there was a lot of work to be done on it, building work equity, sweat equity. You're probably talking another 40 or 50,000 that went into the property and the renovations that needed to take place as well. So you're talking a rough figure of 210 in total.
So basically, she's paid all this money, and now she has no property because she's been evicted from her property.
Yeah, she was evicted in 2016 from the property. It did hit the mainstream news, Manchester Evening News, and other things, which, funnily enough, is how we come to know about it some months after the eviction, when I was shown the very aggressive and hostile. Excessive force, in my opinion, by people that were acting as High Court enforcement agents through High Court Enforcement Group Limited. Yeah.
So basically, now who owns that property?
So my company has owned that property since December 2016. It was legally and lawfully purchased from two companies. I don't know if you're aware of the headline that hit the Daily Mail, and also it went international, but Rekha decided to sell her property to two companies for £2. She sold it to a company called Land and Property Protection Alliance Limited and a company called Fringed Limited for basically £1 to each company. That hit the news, I think, last year. Now, I then came in after that, and I purchased it from them two companies for basically £100 plus other valuable consideration, namely the fact that she was a sitting tenant. So I had to honour the original tenancy of 10 years, which expires in 2026, which was legally assigned by a deed. So it's a tenancy assigned over from the two previous landlords, Land and Property Protection Alliance Limited and Fringe Limited, which was all done by lawyers, regulated SRA lawyers. It was a commercial transaction, and it was all done legally and lawfully, and obviously was submitted to the land registry for registration.
So this is now in your name. You were the landlord.
Yeah.
Rekha was your tenant.
Yeah.
And now
Rekha was paying me a rental on that as well. Yeah.
So then what happened? She's now been evicted.
So she was evicted the first time. Obviously, the sale went through. At the time the sale went through, she was actually back in possession of the property and a sitting tenant. And then what happened was Francis Briley took a claim against both Rekha and myself as a second defendant. Myself as the company that owned the estate, the registered proprietor. Yeah?
And she was supported by the police, wasn't she?
She was absolutely supported by the police, yeah. She's been supported by Derbyshire Constabulary throughout this entire event. To give you an example, every time I've been at the property with official copies of land registry title deeds, I've been arrested by Derbyshire Constabulary. I was arrested back in August. I was held for 9.5 hours the first time, and then I was released without charge pending an investigation. That investigation by Derbyshire Constabulary concluded within 3 weeks, and I received a letter from a PC Mark DC from Derbyshire Constabulary telling me that no further action would be taken against me or my company, that they had clearly obtained the Her Majesty's Land Registry deeds from HM Land Registry on the 4th of September, that they were satisfied that I was the conclusive and registered proprietor of the estate, and therefore no further action would be taken.
Well, Pete, it's quite amazing, isn't it, when we have so many crimes stacking up now, the police won't come and investigate, you're given a crime number, and then those crime numbers are often rescinded. And you've got a situation where a lady is living in her own property and everything is being done legally and lawfully in your side. And the police seem to have this heavy-handed way of getting involved in effectively civil disputes.
A civil matter. Yeah, it's a civil matter, exactly. And one thing we've always said to the constabulary, and obviously they've been on notice for some time, when we say they've been on notice, obviously in August of last year, following my first arrest, Derbyshire Constabulary was served notice that went out to Peter Goodman, who's the Chief Constable. It went out to Deputy Chief Constable Hopkins, and it went out to Craig Sutherland, who's the Force Legal Services Department, head of Legal Services Department, and it also went over to Professional Standards Branch as well within the Force, for them to basically have a legal notice and be advised of what the situation was, and that it was our position that Derbyshire Constabulary were committing the offence of aggravated trespass against us as the company, because they were interfering, as we saw it, they were obstructing and interfering with the lawful business activities of my company. Yeah.
But the interesting thing, Pete, is we haven't actually mentioned the fact that you've been studying law alongside these events, and you're just graduating, so you know exactly the way the law, should work, yes, and how it's not working at all. So anybody watching this program today must be thinking, what is the point of having these courts? These courts are all private corporations. We've got police who are presumably, who's paying them to look after the public?
This is an interesting question, because there's clearly, for want of a better expression, in my opinion, brown envelopes being passed around in this particular case.
Do you feel though, Pete, that this is happening in more and more situations? I mean,
absolutely. This. I believe that this lady back in 2016, when she was evicted, obviously. It shocked me in a way, because I've seen many evictions, I've seen many very aggressive evictions, I've seen armies of police facilitating and aiding evictions, but them evictions have always usually been where there's a mortgage and the banks are heavily involved and the banks want to get their capital back and all that business. I mean, there's also arguments there that banks never actually lend any funds, and that you are the sole creditor when you sign the promissory note. But to step aside from that for a second, as well as the Lord Adair Turner, basically is famously quoted from saying that basically banks don't actually lend anything at all. Lord Adair Turner was, I think, the either finance minister or ex Bank of England governor. But anyway, you can see it online. Lord Adair Turner basically said that banks don't actually lend anything at all in relation to these mortgages. That it's simply an extension of credit, and an extension of credit being that they simply create the funds digitally out of thin air, with say a few strokes of a pen or a few clicks on a keyboard, and all of a sudden there's this loan account. With this amount of credit.
Well, of course, I mean, the banks can lend 90 times their deposits, can't they? Or even more, depending.
Yeah, so yeah, that's how the quantitative easing sort of system
That's right.
works.
So,
Yeah.
so now,
yeah.
how will you proceed now on this case? Reka has now left the property. You're no longer involved in the property. Have you got any court cases pending against you?
So when you say we're no longer involved in the property, we were the registered proprietor. And recently, this week, basically, we have now discovered that HM Land Registry have fraudulently acted against us. So what we mean by that is we need to be very clear on what we're saying. Is because our company legally and lawfully purchased the estate, and obviously we were conclusive owner.
Yeah.
Basically, the state guaranteed to us title absolute with full title guarantee. Yeah.
Yeah.
Nobody nobody at all has a better right to that estate than obviously the company did have. Yeah.
Yeah.
Our lawyers at the time, when they put that transaction through in 2016, also put what they call an anti-fraud restriction on the title. And an anti-fraud restriction is supposed to protect the registered proprietor and the conclusive owner from any attempts of fraud being taken against it. So at the moment, property fraud and land fraud is a huge industry where the law appears to be favouring the perpetrator of the fraud, the actual fraudster, than it does the victim of the fraud. Now, this was never the case with unregistered land. It was never the case with unregistered land because common law would not allow a fraudulent transaction to stand up against a victim. It would always set aside that fraudulent transaction and not allow somebody to gain from something that was fraudulent. Unfortunately, with the way that the registered land regime or system is set up, that is not the case at all. In fact, the law favours the fraudster that commits that fraud and receives title in that name.
Pete, can I just interrupt you?
Yeah.
Do you see that with the advent of digitised land registry,
Yes.
what potential problems will perhaps our viewers have?
Huge ramifications, because we already, in our particular case, we already have evidence, hard evidence, in our possession that one assistant chief land registrar by the name of Chris Day from the Welsh office, and the Welsh office has absolutely nothing to do with my title. My title was managed out of the Nottingham HM Land Registry office, and it says that on my title, that it's to be dealt with exclusively by HM Land Registry Nottingham. So why a Mr. Chris Day from the Welsh Land Registry office as an assistant chief land registrar has been getting involved in my title and deleting, basically he deleted the 10-year tenancy that was registered on there between me and my tenant, which was a deed. It was protected by way of an agreed notice between the two parties. It was on there, which clearly showed that the expiration of that tenancy was 2026. The deed was obviously lodged at the time we registered, because they have to have proof. You can't just put a notice on there and say, well, we've got this tenancy till 2026. You have to actually evidence it by showing the deed that was actually executed, and obviously that had to be certified by lawyers to say it was an original, genuine copy of the original deed that was executed, etc. Obviously all that was put onto the register, and then Chris Day came along about 3 or 4 weeks ago and simply removed that tenancy without notice, without a hearing. It didn't go to the property chamber, it didn't go to the lower chamber, the tribunal, the upper chamber tribunal. It didn't go anywhere. He just simply went onto the system, deleted the tenancy. In my opinion, he knew deliberately that that this fraudulent sale that's just took place this week couldn't have gone through whilst that tenancy was on there. So he actually removed it to help the fraudster get the sale through.
Wow. So basically the police are in cahoots with...
The police are definitively in cahoots.
Gosh.
They're acting privately, and they keep saying that they're acting under a court order from the Manchester High Court. Now, that is an order, a purported order. We've always said it's a purported or an alleged order. In the past, when we've had court claims and we've been in court, whenever we've had any court order, it has always been sent by either the county court or the High Court District Registry in a franked envelope to us, basically giving the order. And sometimes them judgments are signed, sometimes they're not signed. if it's an approved judgment that's been done by, for example, the judgment against the Secretary of State for Work and Pension when I got it was a signed judgment by His Honour Judge Armitage QC, who actually signed it in black ink. Yeah.
Yeah.
So we, in this position, have not had any sight of any order or judgment from the court. What we have had is an order that purports to be from the court, sent to us by Plexus Law, who's a solicitor firm in Leeds. Okay.
Are these? Is it signed by anybody though?
No, absolutely not.
There's no signature on there.
Absolutely not.
So this is fake then?
It appears to be a fake document. We went to the High Court to question its validity in front of His Honour Judge Bird QC in November of last year, and His Honour Judge Bird QC would not give an answer. He just simply kept saying it appears to be that there is an order. And I said, well, appears to be an order is not the same as saying that your colleague, His Honour Judge Pelling QC, has made that order. So I'm asking you again, for the record, is that a genuine order? Has it been made by His Honour Judge Pelling QC? And if so, can I have an approved copy of that order from you, because I've never been served it by the court? And he simply outright refused to deal with the matter, and he simply kept saying to me that it appeared that on its face it was a valid order.
I mean, it's shocking, isn't it? You've got a court system and a police system that are working in tandem, in cahoots with each other, evicting people effectively from their homes.
Tenant of a property,
yeah, and they're actually removing information from the land registry.
Yeah, absolutely.
I mean, recently I posted on my timeline, because we discussed this, didn't we, a fortnight or so ago, and I posted something on my timeline about land registry fraud, and everybody was amazed. They couldn't believe that property was being taken away from people, but it obviously is.
It definitely is. I mean, the restriction that we had, if you can let me just read that out to you, I've got the title deed in front of me here. The restriction that we had on there. So I said we bought the property on the 14th of December 2016. My solicitors dealt with some requisitions that were raised by HM Land Registry, who were my solicitors and conveyancers at the time. At the time, we were acting on their advice on the basis that there was an order for sale. There was an order for sale made in the county court which was void. And do you want me to talk about that and why it was void?
Yeah, why was it void?
Okay, so the order for sale from a Deputy District Judge, Olivia Skates, okay, she is basically a deputy. I don't know if you know this, but a Deputy District Judge is always a judge basically that sits part-time, okay? And they are always usually a solicitor or a lawyer, barrister, whatnot, that's got over 5 years' experience in the legal industry and of good standing. Yeah.
Yeah.
And then they can apply to be what's called a Deputy District Judge. Okay. Well, Olivia Skates, or Deputy District Judge Skates, is exactly that. She is a lawyer in the clinical negligence and medical negligence field, a very successful lawyer by all accounts. She's quite successful in getting multi-million-pound payouts for medical negligence claims. In this particular case, she was sitting as a judge on the 1st of April 2016, where she decided, and it's very, very clear from the transcript, I've received the transcript only 2 weeks back, and she actually admits that she has no experience whatsoever in dealing with property or land law. She actually says this to the barrister on the official approved transcript that came from the court. She then goes to basically take the barrister's lead, because she's obviously trusting that the barrister has more experience than she does. As she's already explained, she has no experience. Yeah. And he starts asking for all kinds of things, extra costs. He starts asking for certain wordings to be put into an order for sale. And she doesn't even know if this wording is correct or if it's a standard wording. She's asking him, "Are you sure that's right? It doesn't quite seem right." And he's just sort of leading her all the way through, where eventually she basically makes an order for sale. Okay.
So it sounds like the blind's leading the blind.
Absolutely.
And they'll both fall in a ditch.
Yeah, and that order for sale, in a nutshell, was void ab initio. So void ab initio, void from the beginning. because the county court actually lacked the requisite jurisdiction to make that order. That's pursuant to the Law of Property Act 1925, specifically Section 3, subsection 7.
But Pete, if you didn't know, if you hadn't been training to become a lawyer,
I wouldn't have had a clue,
you wouldn't have. How are
Absolutely
ordinary
no
people
nonsense.
supposed to navigate their way through this minefield?
It's a minefield. It's a maze, you know. But in simple terms, the way I like to say it is, how on earth can a court grant the neighbour next door a 3,000 term? Create or vest a legal term of 3,000 years absolute to the neighbour next door on this property? I mean, it's ludicrous. She doesn't have any interest in the property. She's never paid anything for the property. She's never paid anything. She's never lent on the property and backed it by any kind of security or interest or charge. It's just absolutely ludicrous. But that is, again, the evidence in our possession. It was completely without merit, without any jurisdiction. That is why we purchased the property. So just to be absolutely clear, we took legal advice on it from very competent SRA licensed solicitors. We'd had everything looked at and done due diligence on the matter, and we decided, right, you know what, we can save this woman here. We can give her a tenancy, and we can get her back in the property so she can actually live there. Because at this point, she was a maths teacher. She'd been off work for 3 or 4 years, in and out of work because of the stress and the length of the litigation that had been ongoing and thinking. She'd paid the £17,500 after the Court of Justice, and now her employer, which was a school, and funnily enough, the council, who had actually worked in cahoots with a neighbour, was trying to get rid of her from the school. So we thought, well, do you know what? We've took this advice. We can purchase this property lawfully and legally. We'll do it all above board, and we can actually stop this fraud in its tracks and stop this lady from obtaining something that she's not actually entitled to have. You know?
Yeah.
Which was this order for sale. Yeah. So that was the basis the company was set up. That was the basis the company transaction went through, and the restriction that the lawyers then put on the title was that no disposition. Now that's a very fancy legal word, but disposition essentially means disposal. So no disposal of that land could be done without a conveyancer signing a certificate, basically proving that the person who was disposing of that land estate or that property had basically signed as Tuncashire Limited, so as my company, and they had to also take reasonable steps to ensure that the officer that had signed on behalf of the company actually held the stated office and was an authorised officer at the time that the document was executed. So questions now need to be raised as to how on earth HM Land Registry have bypassed that anti-fraud restriction that our lawyers put on, yeah?
Yeah.
Because there was never a sale by my company to anybody. You know, my company and no authorised officers of my company have ever signed a sale selling that property to anybody else, okay? And this week, we have been told by HM Land Registry this week, and we've had various conversations. Obviously, this is still live and an ongoing issue, so I'm a little bit limited on what I can tell you in relation to the stuff that's actually happening as it happens now. But HM Land Registry have we've got recorded calls with them this week, basically saying that they don't know why this restriction was usurped, that they can't really give me an answer. All they keep saying to me is that it doesn't sound right. These are the customer support people on the call center when you get through, you know, and that they've raised it higher up as an investigation and a live investigation with the Chief Land Registrar's office, you know. But obviously that's not helping us because, you know, 3 days ago our tenant who was in the property was very forcefully evicted, not by any High Court enforcement groups or agents or officers, but actually this time by the police. Yeah.
Wow, I thought you couldn't find a policeman for love nor money these days.
Oh well, you know that there was 12 of Derbyshire Constabulary's finest
to remove one female, a sole female,
yeah,
from a property.
They were armed with tasers. The video, there's a video on Facebook which I can tag to you and to Miles after the show. I think it's had about 40-something thousand views in the last few days. It's only been online about 3 days, but you'll very clearly hear the officer that breaks into the property shout, taser, taser, officer with a taser. It's all intimidation. It's all fear tactics.
And she was there presumably on her own, and she was being faced with these 12 policemen.
She was, yeah. I mean, we had two situations at the property. So to just briefly explain, we had what's called a Section 6 notice on the garden, and the outbuildings. There's a stone shed and stone garage outbuilding which is combined, which I actually entered peacefully 2 weeks ago with a key. Because obviously, as the registered proprietor, not only does my tenant have a key, but I also have a key. And I entered into the outbuildings with a key peacefully. I then erected the Section 6 notices. A Section 6 notice is basically where you formally state that you are occupying that land. It's a legal warning and notice that you are occupying that land, and that you are opposed to anybody using force or violence or entering upon that land that hasn't got the court possession order or rights. So basically what you're saying is that you need to go to court and get an order to get us off, and that nobody, including the police, can come on, and it's a civil matter essentially.
So you put notices up on the property.
We put the notices up on the garage and the outbuildings, stone outbuildings on the shed. They were on every window on that outbuilding. They were on every door on that outbuilding. They were laminated. They were affixed by cable ties to the gate of the garden.
And you know how to do this because you've been qualifying in law.
Yeah, because I've done it before, and simply because also it's a very successful method, and it's how the anti-fracking communities across the country have occupied neighbouring fields to where gas or unconventional exploration or drilling has been taking place, by occupying land in and around that area so that they can camp and protest on neighbouring fields and neighbouring owners' fields. Fairly peacefully. So in order for that to happen is that person who actually owns that particular piece of land that they're now occupying would then have to go to court and get a possession order. Yeah. And we've been very successful, and that particular movement has been very successful in doing it. And it's always been a case that the police will not entertain going into a Section 6 cordoned area, because obviously we had people living in tents on that site as well. There were 2 tents erected in the garden, and also cable-tied laminated notices against them tents as well.
So this was in Recker's Garden, that was?
Absolutely, yeah. And that was the case for a couple of weeks. And it worked for a few days.
Did the police actually come and have a look at these notices? Or did you write to them?
Yeah. The police came, and then PC Bennett actually came very forcefully, and on one particular day, it jumped over the fence in the garden, removed the stones that were against the gate to prohibit anyone from. We had basically large granite stones, if you want to call it that, against the gate to stop anyone opening the gate, basically. And he removed the stones, and he let 2 builders in. These builders were apparently employed by the fraudster John, who is now claiming to own our property. Yeah.
Right.
So they had tools and machinery on the property. We weren't aware that they had tools and machinery on the property, but they had a cement mixer. They had lawnmower, some tarpaulin. They had some aggregate, some stones, some building merchant supplies, and some turf up on the land. So instead of asking us, would we allow the builders to come onto the land and remove their property, they didn't do that. They simply got the police officer to climb over, remove the stones, allow two builders or garden maintenance people, whoever they were, to come onto the property, remove their gear. There was a bit of an issue initially, because obviously I'm heard on camera asking what the police officer thinks he's doing and who these people are that he's just decided to bring onto my land. Eventually it transpires that it were workmen or whatever that were coming to get their property off the land, and he was allegedly there just to facilitate that there was not going to be a breach of the peace, But he went way above that, and you can actually hear him on camera state that he knows he's not got any right to be on the land. He came in an unmarked police car, and he wasn't in uniform when he came either. He wasn't displaying his shoulder epaulets. or other parts of the uniform.
Did he give you his number? Because it seems to me these days that the police do not like to give their number out.
He did actually, yeah.
That's amazing.
He announced himself as PC Bennett with an associated number. We have since obviously had conversations with PC Bennett afterwards, where he refused point blank to look at the registered title and the official copy of the title that I tried to serve on him, letting it drop to the floor.
It's just shocking, isn't it? Well, I think really, Pete, there's a lot for people to take in tonight. We're inviting you and your colleague, Ken, to come on the show in a couple of weeks' time. And I think we can perhaps clarify lots of the issues that you've raised tonight. Obviously, this case will have moved on.
It will have moved on, yeah. We've got obviously a lot of work going on as we speak. We've got lawyers that we're actually in talks with this week that are willing to take actions against the police, both in a private prosecution fashion and also in a civil damages fashion.
Who's funding this, Pete, may I ask?
Pardon?
Who's funding these lawyers?
Well, that's to be discussed at this minute in time. So we've had the calls, and they're actually wanting to travel up to see us, which is quite unusual because usually you're told to go and see them, and they're actually down south. But they're actually wanting to travel to us, given the nature and the high profileness of what is actually happening here.
Because of course you've been in the papers, or this case has been in the papers on more than 2 occasions now.
Yeah, it has in previous matters, but obviously nothing in relation to obviously ourselves and the situation that we found ourselves in, where our property and title to our property has literally been stolen and transferred into the name of a fraudster, basically.
So when does the land registry go totally digitised? Do we know yet?
Well, it pretty much already has in some respects, because what happens now is no matter which office you send papers to, so whether you send it to Hull, Wales, Birkenhead, Nottingham, wherever, Gloucester, as soon as that office receives the papers, what happens is it is sent to like a bulk administrative centre.
Yeah.
And that administrative centre is a PO box in Gloucester. Okay.
Yeah.
That office then bulk scan every piece of paper digitally onto a system, and then once that system has that scanned on, they can then transfer that to anybody in HM Land Registry at the touch of a button, very quickly. And then what they do is they call it dematerialise. They dematerialise the either the originals or the certified copies of the originals that you've sent in. And it's very important, especially for people that aren't using lawyers. I mean, most people do use lawyers, to be fair, to purchase property and conveyances, etc. But if people aren't doing that, they may find that they send their original deeds to the land registry, and actually they won't get them back because they're automatically dematerialised, and there's no mechanism to retain them. Yeah.
Well, I mean, there are a lot of people that don't trust anything digitised, and there'll be a lot of probably worried people hearing your story. And I just would like to say thank you, Pete, for coming onto the show. And we look forward to hearing from you and Ken in the studios in a couple of weeks' time. And, there's been comments made on Facebook, and hopefully you can get round to answering them.
For sure, yeah.
All the queries.
We'll definitely check all the comments. Yeah.
Okay, well, thank you so much. And it's good night from us here in Wiltshire. Good night.
Thank you. Good night.
Thank you.
Welcome to Stepping Stones. John Smith, A Lawful Rebellion, interview by Caroline Stephens. Caroline, take it away.
Okay, welcome to Stepping Stones interview. I've got John Smith from the Common Law Courts on tonight. John is live from Skype in Scotland. John, welcome. You have been in the casino industry, and you're going to talk through a little bit about your background and how you embarked on the common law jurisdiction. Over to you, John, and welcome.
Hello, good evening, Caroline, and hello to your viewers. I started off, like many people, in a 9-to-5 job, working within the casino industry. I did a 21-year career within the industry, managed to progress through all the different categories and the grades up to the position of general manager. At that point, after a 21-year career, I actually fell foul because I was working for a couple of directors who were bypassing some of the legislation under which we operate. Long and short story was I effectively ended up as a whistleblower, and after which the directors decided to go in the attack mode. I ended up not working in the industry again, lost the career, finished me off. But when I turned to the gaming industry regulators at the time for protection, instead of assisting me, they actually covered things up to protect themselves. It involved large sums of money, and it would have affected the government income by way of taxes. So instead of...
Just interrupt you, how would it have affected the government? Was that on the taxation side?
Yes, the government makes literally millions and millions of pounds through the industry. They had set up the industry in such a way that they let the public believe that they were actually protected, which was not the case because there was major flaws in the industry. And at the time when I was working, Tessa Jowl was working for the Department of Culture, Media and Sport. She was actually in charge of the gaming industry, and when they were aware of what was going on, instead of addressing it and highlighting the problem, they decided to cover up their negligence, and in so keeping the secret away from the public. If the public were aware of what was going on, it would have had a huge impact on the industry, and it would have affected them financially through loss of revenue and taxes. It was after that time, because this had happened, I then decided to go to the statutory system to try and seek justice or look for a lawful remedy. At the time, I would have been probably in the region of 40-year-old. Having lived all my life in a sort of cloud, been protected, I didn't realise that the statutory system is not actually set up to ensure. But at the end of the day, I actually found out that instead of offering a lawful remedy, they basically protected the state and vested interests. I ended up bankrupt, I lost my career, broke up the family, I basically had, I was unemployable because of what had happened to my name and reputation, and as such, I'd walked away losing everything.
Do you mean, when you say losing everything, is that the house or?
Yes, everything. House, family, career, 21-year career, reputation, literally everything, financial savings, everything I'd lost.
And where were you living then at that point?
Well, at the time when I lost initially, I had to go and stay with my daughter, who had managed to obtain a council house. So I stayed with her short term, and then I moved away and obviously relocated in a different city. And after the split from the family, I then obviously had a new partner relationship later on, and I've been staying with a partner ever since, but I've had to relocate cities, and the dispute is still ongoing, simply because although everything that I've said has been proven, regardless of what happened previously, the gaming industry would not put things right. They would not admit negligence. They didn't want the information getting out, and literally I've been made to suffer, and I still continue to do so because they wouldn't put it right.
John, can I interrupt you there? Because I've had sort of, I've had people who've gone through whistleblowing situations in the past, and when they've been working for an employer, they often go through some sort of tribunal system, like rounds of tribunals, internal systems, and they basically, the employer gleans information from the employee, retains it, and then it often is used against the employee in the next round of the tribunal. Is this the sort of thing that happened to you? So they were collating evidence back onto yourself?
Not necessarily. What actually happened, I'd been working for large PLCs within the industry for a number of years. The final PLC I was working for had announced to all the general managers that they were going to sell off the company. Now, at the time, we didn't know who was going to purchase the chain of casinos, so we weren't sure who it would be working for. At that time, I was offered the position to go and work for an independent company, a couple of casino directors. So I decided to take them up on a 5-year contract, a fixed-term contract, with various bonuses built in based on profitability. I'd actually been very, very successful, but throughout the first year I knew there was problems ongoing. So for the last 3 or 4 months I worked there, I spoke to the directors, dealt with it. Unfortunately, as the general manager, my neck was on the line because I was ultimately in charge of the casino. And when it came to a standoff, they wouldn't deal with it. I then walked away. I'd actually left after about 13 months, but when I initially went to a tribunal, they argued in a technicality about the contract, and it was decided that I was actually 5 weeks short of taking him to a tribunal. So that was the first strike against me. I then decided to go to a statutory court to obtain a lawful remedy, and at the same time, being advised by a solicitor, we also submitted an objection to the casino licence renewal. When we'd done that, the directors then went on the attack, went for me and basically stated that I was malicious, vexatious, and basically that the allegations I brought forward had no basis. So without viewing any evidence, the licensing board decided to renew the licence, and without having any evidence against me, they decided to award expenses against me, breaching the rules and the setup, the chain of command. I took initially that decision to the Court of Session in Scotland, and the licensing board admitted that they were wrong, so they withdrew immediately. But instead of putting things right, the Court of Session referred the matter back to the council to deal with again. It took about 7-8 months to get back there, and when we got back to the hearing, they just ignored everything, refused to discuss it, confirmed that the decision was correct, and that was the end of it. Now, because of the attack by the directors, I'd ended up losing the £17,000 I had in savings. I'd run out of money. I was then when I applied for legal aid, and I was refused legal aid for various reasons. I don't know why. Probably because I was taking on the government agency or a licensing authority. I was refused there, and then shortly after I was made bankrupt. So for 3 years I couldn't do anything at all, and then after 3 years I decided to go back to the courts to try and obtain a lawful redress, because during the interim I'd actually received concrete evidence confirming that I was correct. Now, despite having this evidence, when I went to the court, they then decided that they wouldn't accept it, and they said that the issue was time barred, regardless of the fact I'd been sequestrated and it affected my position to proceed, and that the bankruptcy trustee wouldn't allow me to proceed.
So basically, can I just interrupt you, John? So let me just get this right. So you went to court, they didn't accept any of your evidence. You spent £60,000-70,000 of your savings that bankrupted you. You then couldn't do anything for 3 years. What is the legal aid situation like now in Scotland then? I mean, they've been clamping down, certainly in England, as to being entitlements on legal aid.
It's literally non-existent. I've actually applied for legal on 4 or 5 different occasions, and bearing in mind that I had no income and I hadn't been working, I didn't actually claim any benefits. I'd lived off savings I had, and with family, I had support from family and friends as well. I didn't actually decide to claim any benefits. I tried to obviously obtain a lawful remedy and redress the situation through the courts. Now, I'd applied to the Legal Aid Board and asked on 5 separate occasions for assistance, and each time they turned me down, saying that it was not in the public interest to proceed.
Not in the public interest?
Yes. Now, bearing in mind, the initial problem stemmed from a licensed premises, which were a casino. It was company directors, it was fraudulent behaviour, it was a breach of the gaming laws, it involved about 60,000 casino members in illegal gaming, and fraudulent councillors who'd made an unlawful decision, and all this wasn't in the public interest.
Right, so we've got councillors, corrupt councillors, we've got licensed premises, and we've got presumably judges involved, yes. So the judiciary as well. So, yes. So they're all literally into bed with each other.
And also the government as well. At the time I dealt with government ministers, and at the time it was previously known as the Gaming Board for Great Britain. It's now changed to the Gambling Commission. I was there at the overlap, and the chief gaming inspector from the gaming board had admitted that I was correct to an MSP. So I have the appropriate documentation from him confirming that what had happened to me should have never have happened, it should be overturned, and that I was correct. Now, having this information and returning to the local licensing authority, they had decided that they couldn't do anything, they weren't going to do anything, and if I wasn't happy, I had to go back to the Court of Session. So when I went back to the Court of Session in Scotland and submitted the relevant papers, the Lord who decided to view the paperwork decided that they wouldn't allow me to proceed. They said that there was no reason for doing so because I was no longer bankrupt, and regardless of what happened previously, you can only proceed if you obtain the services of an advocate, obviously Queen's Counsel, which would have cost thousands of pounds to do, and I had no income, and they wouldn't give legal aid. So therefore I was deprived yet again through the judicial system.
So had you managed to find work by this time?
No. I hadn't done anything. I said I'd been living off obviously what I did have. I ended up bankrupt, but I'd been trying to address this, and it was then that I started to look into other alternative remedies for a lawful remedy. Because I then found out for the first time in my life that when you had a problem, you didn't automatically go to the state. I believed at the time when there was a problem, it was regarding a legal issue, you would automatically turn to a solicitor, which is now the last thing that I would do, having discovered the information I do know. But having taken a couple of years to work out what the problem was, and then having a look at the system, then realised to use common law to obviously obtain a lawful remedy and deal with it that way.
So how did you, so the common law side, did you actually meet somebody who talked to you about common law, or did you take it upon yourself to investigate further?
I think what I'd done initially, because there had been ongoing problems with my case, and because it was sort of watertight, and basically there was no doubt whatsoever that I was wrong. When I then realised that they were ganging up on me, so to speak, for various reasons which may be unknown to myself, basically I was hung out to dry. Now, because I was correct, and because there was no valid reason for doing what they did, there had to be something there going on in the background. We started to look at the legal system, and we found out that the various judges within the system and the various level of courts and the authorities and councillors were all, for various reasons, failing to comply with the requirements. They were not doing the job, they were not following their own rules, they were basically breaking all the rules and doing whatever they wanted to do. Now, having learned about that and spoke to various people about that, I then started to examine the judicial system. It was that point I then started to educate myself, watch lots of people, watch lots of videos, find out as much as I could about common law, and then through speaking to various people that I'd known, we then started to put together something in relation to a common law defence. So we've obviously set up something to address that, and it seems to be working just now.
Right, so how many people are involved with you on this common law system, the common law courts?
86 million.
86 million?
No. Basically, the common law, when we speak about the common law court, it's not a company, it's not an entity, it's not a charity. It's literally a process that's available to the public, predominantly because I'm based in Great Britain. This is something that's available to everyone in the UK. Now, there's not a building, it's fixed, it's a common law court building. It's a process which people can use to obtain a lawful remedy under common law. So therefore, there was recently 5 court cases convened in England, down in Ascot, beside Glastonbury. Now, the 5 individuals who convened the court were actually English people from the area, and they put forward their cases which were convened, and it was dealt with by the public. So it has nothing to do with me, it has nothing to do with a building, it was a process that people can actually use.
You've got a website, haven't you, the Common Law
Yes.
Courts. We're going to display that on this show. So I noticed on Facebook a couple of days ago, I think there's going to be one, is there in Doncaster? Yorkshire, later this week. Would that be right?
Not that I'm aware of. Not that I'm aware of just now.
So people can just set up these. Do they go to your website and follow the process that's laid out on there?
I think what we've done just now is realistic. If we're speaking about lawful remedy, people cannot just go ahead and try to convene a court and set it up. Realistically, that has to be a lawful procedure. It has to be run correctly, and the decisions to validate court decisions, they must be reached in a reasonable or lawful process. So what we've actually done just now is said, look, the first common law court was convened by myself last year on the 11th of June.
That was the first one?
Yes, that was the first one. And now I reckon, realistically, it's probably the first of its kind for probably about 800 years.
Right, so can we just go over it? The one that you were involved in last year?
Yes.
You brought 12 people together to act as a jury.
Well, there was actually more than that. What we actually do is we make the information available through the public. We confirm that we're going to convene a court. Having done so, I require a lawful remedy. So there's a notice put up to inform the public, and then any members of the public could attend on the day in question. When they do so, a presentation is given to them to explain exactly what we're trying to do. And then we explain about the jury, we explain about the court officers, about the procedure, and then we ask for volunteers. So volunteers, a member of the public, are used to set up the court, to establish the court officers, so to speak, and then to get the jury. They're then sworn in, the relevant paperwork's completed, and then we just press on with the trial. The plaintiff then would present their statement of claim to the jury and present their case. Now, when we actually convened the first course, it was by way of a summary process, which basically is the same as the statutory system. It basically means that you have one individual placing their evidence before the jury and asking the court to issue an order. So that's it. If obviously the recent cases we had in Ascot, what we do there is it was a full court hearing and the opposition were actually summoned to appear. So the court summonses are sent out to the opposition. The defendants are then given the right to respond, submit a written response. They also have the opportunity to meet up for a pre-trial conference to settle the dispute amicably before the hearing. Failing that, the parties concerned will then attend to the hearing, the actual court trial. The court will be convened and then the case is put before the court and the jury.
John, can I just interrupt you there? So you called the defendants to the trial. What happens if they had turned round and said they weren't going to turn up?
Well, what's happened just now is with individuals, when you summon them, the court is, the papers are summoned to them. It's just like a normal court summons. The options are you can actually adjourn the court and you can actually issue court officers to basically go and sort of arrest them and take them. They have the authority to take them to the jury. There's no point in doing this. The easiest way to deal with it is if the individuals have returned paperwork by way of a written defence, even if they didn't appear on the day in question, what you would actually do is you would have to select a member of the public to read out their defence. So a member of the public would basically be representing them. The paperwork would be read to the court and then that and nothing more because they're not there to answer. However, if the defendant doesn't submit a written defence, basically there's no defence to offer up. So the plaintiff puts forward the evidence, the paperwork, and the statement of claim to the jury, the presentation. If the jury have one or two questions just for clarification, we can then find out what they want to know. The jury then convene, and based on the information put before them, they then deliberate and pass a verdict.
So what sort of remedies can you actually mete out, if you like? What is it successful?
Yes, I would say yes. I would say yes just now because it is working. Just to clarify sort of the authenticity of the court and the statute, the paperwork that's issued. When we convened the first court last year, the process, the website was set up for one purpose and one purpose only. It was actually, once you convene a court, a lawful court, you have to make the information public. So therefore, the findings of the court hearing and all the paperwork has to be made available. And I thought, well, the easiest way to deal with that is to set up a website and leave it open source. So the website was set up to record information for the Common Law Court and also to pass on information about common law. And that was it. So that is the only connection with the Common Law Court. Now, when we've done that, various people had contacted me and said, look, can we use this process as well? So we explained, look, this process has nothing to do with an individual. It's something that anyone can use. And when people started realising that this was available, they then decided to use it themselves. So
John, my mind's working overtime at the minute, because we're all complaining about treacherous MPs. Can we start putting them through this court system? Because I think there'd be a queue a mile long to serve on the jury.
Yes.
So
Yes,
we'd have a court in each constituency for all the, each MP.
Yes.
Really? Oh, wow. Anybody watching this tonight, this is exciting, isn't it?
But bearing in mind, the jury should be impartial.
Well, I mean, we want to get independent MPs into Parliament. In 2016, it's alleged that 164 of our MPs were actually on the sex offenders register. I mean, it doesn't really stack up that these people are telling us how to live our lives. Yeah. So, they've all got shares in Big Pharma. We were taken into the EEC without jurisdiction. That falls outside the common law. We were taken in illegally, weren't we, with the Foreign Commonwealth Papers. What can we do here?
What you've got to remember is the system, if it comes down to basic principles of common law, is everyone, every man or woman, is held accountable for their actions. So whether it's an employee for the state that's maybe negligent or maybe criminal, when they're actually doing things which people are affecting people and people are actually suffering because of it, it's no longer acceptable then to pay them a huge pension and a huge payoff just to give them a pushy number somewhere. If someone stuffs up, they should be held accountable, especially when people are suffering. They shouldn't be paid, and if their actions are criminal, they should be sentenced accordingly. Now, I've dealt with people who have tackled the situation I've been dealing with, and I know that they've been committing crimes. Unfortunately, the state protects them. Now, for various reasons, people are protected within the state, and the last thing that a member of the public needs to know is that if something is happening and it's affecting themselves and their family, they're being attacked by the state, they need to know that these people will be held accountable. Unfortunately, within the statutory system, they're not held accountable. And on that point, within the judicial system, the thing which is annoying about and frustrating is the system is set up. You do not have a lawful remedy through that. It's not set up for justice. But actually, the court system in this country are all companies. They're registered companies running for a profit. Now, the judges themselves, throughout the courts and in sheriffs in Scotland, they don't actually follow their own rules.
Right, so can I just go over that, John? Just each court is a private corporation.
Yes.
And they're all different corporations, or are they all part of the same big corporation?
They work under a main banner. Some of them
it's like McDonald's, they all have a franchise.
Yeah, some of them actually work under a larger banner, and some of them work independently. Basically, from what I've been led to believe, through trying to find out up in Scotland, this is about the system up here. They like to think they're different here, and they try to separate the countries here. But basically, at the end of the day, in Great Britain, it's just a common law jurisdiction. If you want to claim common law, it's common law, and that's it, end of the story. The state actually dictate otherwise, and they say, no, this is what we're going to do. And they separate the people into different communities. They do what they want. Now, in relation to the legal system in Scotland, the judicial system, so shall we say, what I've found out is that it comes under a banner, 2 or 3 banners, but predominantly maybe the Scottish Court Service. Now, the Scottish Court Service is a company, but you couldn't actually find any trace of it in Companies House. Thought strange. Well, why is that? Well, first of all, they don't want the people to know that it's not there for justice, and they don't want people to know it's a company trading for profit. So they've actually hidden the fact. So researching it and trying to find out, after a bit of digging, I found out that the Scottish Court Service is in fact a registered company, but it's registered in New York in America. So it doesn't come up in Companies House in the UK.
Really? That's sneaky.
I also found out that for some reason the Scottish Parliament, because of the taxpayers' money that comes in, the same will be for the UK Parliament as well, but using Scotland because I'm based here, Scottish Parliament, they are recorded at Companies House, and basically everything in the account and the money that comes in is available through abbreviated accounts to the public. However, the Scottish Government is not a company in Companies House, but the Scottish Government is a registered company over in New York.
Scottish Government is a registered
company in New York.
New York?
Yes, in America.
Right.
So basically what you have is the Scottish Government is a registered company over in America, it's bound by the rules in America, and basically it stands as an American company, which the people don't know. Now, the UK Parliament is similar. This is, I think at one point I was actually given information from people that one of the major companies is a credit company, basically ranks every single company in the world. It's Dun & Bradstreet. Now, if you go into Dun & Bradstreet, you can actually find out that they're all registered, whether it's things like the Conservative Party, Tory Party, Labour Party, it says governments, offices, they're all basically registered companies, and some are registered through individuals as well. Now, I don't have a problem with the system. I think the system is great. I think the way we live is great, it's fine, other than one thing: the people that run it are corrupt. I says, if the people were to run it properly under the principles of common law, we would have a great system. The people would be protected, there'd be no harm, loss and injury caused, and basically we can all live and just work together, that'd be fine. But because for unknown reasons, the individuals get themselves into positions, a clique of people, and for various reasons themselves, they decide that they're going to dictate how the country is run. Now again, without getting into issues regarding Brexit and things like that, it's not down to the people. Although the government are supposed to work for the people, the statutory system and the authorities work for the people, but you wouldn't actually think it, because they actually decide how we're going to run the company, how you operate, and the people, the members of the public, are actually just told what to do, and that's it. Now, I think it's back to front. It should be the other way around. That obviously the state works for the people, but because it doesn't seem to be that way just now, there's something far wrong with the system.
Well, I mean, I spoke to Dominic Grieve in April, and I said to him, if you understand what common law is about, surely the people are in charge. It's the people that have the powers. And he said, no, it's not. It's Parliament is sovereign, and the MPs can do what they want. So what do you think to that, John?
No, crap. At the end of the day, people, the country is the people. At the end of the day, that's it. As the Parliament, the government is only there because of the people. It's people that have the say, the people that have the authority. The people determine what goes on. The power in a country and the authority is the people. As they dictate what goes on.
So what shall we do then? How shall we plan a way forward? How we take back control of this country lawfully, peacefully, without injury? How do we do that?
I think at this moment in time, given the work certainly with the Common Law Court, I think it's a great start, because what you're actually doing is you're addressing the system which is failing just now and which is in trouble. You're taking that and you're improving it and making sure that it's rectified and the solutions are found, and the problems are solved. But what you do is you do so by holding individuals accountable. So if you have any issue, now again, it could be anything from NHS, it could be education, it could be the court system, it could be police, it could be anyone. Regardless of the position they're in, if people are there not doing what they should be doing, it's either negligent, in which case you remove them, or if it's even criminal, they should be held accountable. Now, if you start holding these people accountable for their actions personally, and they cannot hide behind the state, then things will change for the better. At this moment in time, this is people are in positions, they shouldn't be in the positions because first of all, they're incompetent. So I'm not saying that for everyone because there may be lots of people in positions that are good.
John, can I just interrupt you there? Because that's a really important point, actually. Because I went to a Veterans for Britain event last October, and I listened to people like Colonel Richard Kemp and Brigadier General Julian Thompson looking extremely worried about the European PESCO, the Permanent Structured Cooperation situation, where we were going to give all our armed forces to Brussels. Of course, this weekend we've just had the Armed Forces Day, and I was talking to all the different armed forces in town. They all had stalls out, and not one person knew about the PESCO, the Permanent Structured Cooperation. They would just simply say, "Oh, we work on manoeuvres with other countries." I said, no, this is more than that. I said, this is actually handing over our military to the Brussels jurisdiction. And they looked in disbelief. I'll be perfectly honest. And you see, when I went to the Veterans for Britain event, it was a case of the guys would say, well, the civil servants bring out a dusty document from a vault somewhere and the MPs would sign it. I mean, that is negligence of the highest order. I mean, we need to be getting these MPs up front now into this common law court system, and we need to be trying them, every single one of them, because they're allowing all this to happen. We wrote to all the MPs. There's not one MP probably on PESCO that we didn't write to, and yet we just got a load of rubbish back from them, to be perfectly honest. They didn't seem that bothered.
Unfortunately, to be quite honest, I was guilty as the rest. This is because up to probably the age of about 40-year-old, I was oblivious to anything that was going on. I had a comfortable life with a family, had a nice career, a nice job, a nice salary. It was fine. Everything was okay. It wasn't until I decided, obviously, I was actually forced into the position to protect myself, but became a whistleblower. Then when I turned around and said, look, I need assistance here, I then realised exactly what was going on. I hadn't realised, how bad things were, and it was only then that I started to open my eyes. Now, learning very quickly through other people, I then found out how the system works, and also the fact that it's not set up to protect people. Now, you discuss things like the military situation just now. The majority of people in this country do not understand what's going on. Now, it's done that way because the government don't want it to be known what's going on. The people in government basically have their own agendas for whatever reason, and they decide to obviously concoct various deals, various contracts, various pieces of legislation to keep themselves happy, to keep themselves in a nice a cocoon away from everyone else, and basically pretty much sod the people. That's what it boils down to.
Well, John, of course you know that we've just had the Melanie Shaw remand hearing today, and we're going to be hopefully following up on this next week. You've got some presentations you're giving at the end of this month, is that right? Guildford and York?
Guildford on the 22nd of July in Guildford, and there's one coming up on the 4th of August in York. I think there's 4 or 5 speakers there. The one in Guildford will just be on the common law court, so we'll just be myself there. But that's by way of a seminar to discuss what we're doing.
John, so how can the people who are watching tonight on Facebook especially find out about these two events? Are they shown on your website, or are they coming up on your website?
There's something just been put on the Facebook page, a link to the one in Guildford. The information will go into the common law court site within the next day or so, but the first one is actually advertised on the Facebook site now, and you can get that. So there's a link there, but we will set up something on the common law court site as well.
What is the Facebook page actually called? Is it Common Law Courts?
Law Court, yeah, Common Law Court.
Can anybody actually access it without having joined it? If they have to pass the test for the questions, is that the situation? Can anybody look at these dates?
But at the end of the day, it doesn't make any difference. It's available to everyone, to the public. As I said, it's the common law court. When people ask occasionally, they say, well, yes, we've heard about the common law court. Who is the common law court? Or they say, where is the common law court? There's not a building.
No. Can be anywhere, presumably.
And at the end of the day, the common law court is the people.
Yeah,
basically,
we the people.
If you're being attacked, you have a problem, and there's a dispute, and you wish to hold someone accountable, you can be in a court yourself. And with the public, you set it back, so you go back to the basics. Now, when people go on about previous legislation from the state as well, you go back hundreds of years, even the Magna Carta. But realistically, as far as we can see from research, you need to go back probably about 100 years before the Magna Carta until such time that these courts were convened. Because after that, and the build-up to the Magna Carta, what happened is the state then got involved in the judicial system, whereby it may have been King John at the time, it would have been the lords, the barons, the sheriffs in the area. They actually took over the justice system by convening courts. Now, as soon as these people take over the system, it then becomes a statutory system. It's run by the government or the authorities. It's not run by the people.
Well, as you say, the Magna Carta 1215, I mean, that was 800 years ago. We had big celebrations. David Cameron was involved in those celebrations. He gave £1 million to celebrate. So we must take him up at his word, and we must reinforce the Magna Carta. I mean, I've signed my Article 61 oath. Have you done yours, John?
Yes, I have, years ago.
Right, okay. I met a baron actually just before Christmas, and it was really interesting to hear why the barons, 25 barons, got together in 2001 to petition the Queen and about the closer integration with the EU. They were ignored at the time. Should they have petitioned somebody else other than the Queen? Should they have petitioned her office, for example? Did they do it the right way? What happened there? Do you know?
The systems that stands just now, and based on the Magna Carta, there was a process in place to deal with it. Unfortunately, that only works if all the parties comply. Unfortunately, it's a bit one-sided because the Queen and the state would not accept what was going on. They're quite happy for that and quite happy to cover up. So therefore, you have a problem. Unfortunately, he says, if you then come out of that and stop to think about it, say, well, hold on, there's a problem here, we need to address it. You address it through the common law courts with the people.
Woohoo! So, John, just to wrap this up, we've given people the dates. They can find out your Facebook page. You've also got the website, which we've been showing on the bottom of our screen. Yep. And we would like to invite you back on next time, very shortly. And we want to follow up on the Melanie Shaw case. And no doubt we're going to talk about your future common law courts and what success you're having. So, John, is there anything else you'd like to say to the viewers before we say goodbye?
No, I just thank you for joining. And remember, this is that while we're discussing common law courts, it's not my common law court. It's the people's common law courts. This is the common law courts I use for the people, and it's basically down to them to convene their own courts. Providing they follow the process, it'll be okay. Well,
thank you, John. And, we did say in Vote Leave, power back to the people. We will take back control. So thank you, John, and thanks to everybody listening. We the people will take back control. Thank you.
Bye.
Bye.
Welcome. This is a live with John Smith, a lawful rebellion, a lawful remedy, a Stepping Stones interview with Caroline Stephens, and we'll give you over to Caroline. Stand by. You're live.
Welcome to a Stepping Stone series. I'm with John Smith today. John Smith is part of the common law court system, and John is going to talk about a lawful remedy part 2. John is based in Scotland, and he's going to share his expertise with us now. Welcome, John. Thank you so much for joining us. Now, we've already covered a lawful remedy in part 1 earlier. Part 2, we're going to look at the Magna Carta, or are we going to look at the Magna Carta? Over to you, John.
Thank you, Caroline. Welcome to your viewers. In relation to common law, you mentioned the Magna Carta just now. The same probably would be applicable to the Bill of Rights and also the Declaration of Arbroath in Scotland. While these documents are actually quite good and the foundation of the system has been based upon these documents, they're not always beneficial to the public in general. I think obviously some of these documents are set up to protect the state, the individuals in charge, and in relation to the people, many of the people are neglected.
Sorry, John, I didn't understand. I didn't realise that. So under Magna Carta, sometimes effectively the establishment's protected rather than the people.
Well, if you look at the Magna Carta, the original agreement, when it was drafted up because of the Baron's complaint with King John.
That's right.
The dispute was over the authority, and basically says the standing of the barons and the authority of the king in taxes and various other problems. But the dispute arose between these parties. So the barons had wanted to set up something with the crown to make sure that they were protected and their lands were protected. So while the basis of the Magna Carta was drafted to deal with these internal disputes between the barons and the crown, they decided then to put in some of the information to assist with the, let's say, the people or the peasants. So
people of what, sorry?
People, or what we call them, the peasants.
Right, okay. You mean us?
Yes, us. Basically the commoners. Now, there's, without a doubt, there are things in the Magna Carta which is beneficial and has been used, so it does benefit the people in general. However, I said, people should not forget that the original Magna Carta was drafted because of a dispute between the barons and the king. So when the king and the barons sit down to divide up their estate and decide what they're going to do, I don't think the people actually got a lot of recognition there. So obviously I think first and foremost this was drafted to address the quarrels between them, and then they added additional things in to protect the people, rightly so, and it has been used. It's laid a foundation which is great, but obviously it wasn't predominantly laid down just to protect the people. Similarly with the Bill of Rights and in Scotland the Declaration of Arbroath. All these things were set up and drafted because of the authority, the crown, the barons in charge, the lords, the lairds, and again this is a token gesture was given to the people to protect the people. So when we've actually looked at this in relation to the judicial system and protecting the people's inherent birthrights, we then go back to basic principles, our first principles, and we say, look, strip everything away. It boils down to basically people's inherent birthrights.
John, can I just interrupt you? Because most people, the majority, I think, who are going to be listening to this video are probably living south of the border. Could you explain what the Declaration of Arbroath is, please?
The long and short of it was that because of the battle between the Scots and the English and the Crown at the time, basically says the English were coming in, putting forward various declarations and decided this is what they're going to do with the lands in Scotland. This is the control they had over the Crown at the time and the various lords in Scotland. And basically they turned around, the Scotsmen declared, obviously made a declaration.
When was this?
Oh God, it was tell you what, I can't remember.
It was before the Declaration, before the Bill of Rights, though.
Yes, way before.
Well before.
I think what had happened is the Declaration of Arbroath was actually set up at the time. I think it was Robert the Bruce and the noblemen in Scotland. They decided, obviously, they didn't want English rule, so they drafted a declaration out, and they submitted it to the Pope, basically claiming sovereignty for the nation and the people. And the long and short of it is saying that as long as there was 100 of us stood together, we will never be taken over by the English. That was it. So it's symbolic, the gesture of 100 people or 100 Scotsmen standing together. As long as we have 100 Scotsmen, we'll never succumb to the rule of the English.
Oh, right, okay. That's worth knowing.
That in itself is fine, but it says using that, we can then use this and make it applicable to everyone in the UK. It says realistically, it says, I think the division between the countries in the UK has predominantly been down to the Crown, the governments, and I think it's a way of colouring what's actually happening in day-to-day life. And I think it's obviously used to try and keep the people at loggerheads to cause disputes, disruption, whereas the people live in the UK, they live together and they live under one jurisdiction, which is common law.
So in actual fact, the governments they're happy for us to be divided in lots of different ways, aren't they? Whether you're wearing a party rosette, the colour of your skin, your religion, but this is the only way that the people can take back control.
Yes.
Yeah?
Yeah. You look every day in daily life, there's divisions everywhere. It doesn't matter what you do, so there is divisions, it's just the way it works. Basically, so the government in particular, pride themselves in causing disruption. It doesn't matter what you do, there's an argument about anything. The way they operate, they're not open, they're not honest, and it causes friction. The media, to a certain extent, put out information which obviously panics people as well, causes obviously concern in everyday life. So people, instead of dealing with things rationally and thinking about what's actually happening, they're actually worrying about petty issues which have been created by the state or the authorities to try and obviously distract from what's actually happening. You look at the issues you mentioned earlier about Brexit. You've got things which are happening just now which are crucial, and yet instead of coming to the forefront and discussing these things, we're arguing about the latest episode of Love Island on television, or the state of the football, or obviously it says grooming gangs or something like this. It's all side issues that obviously are thrown to the people to get the people quarrelling about things or arguing about minor things, which at the end of the day, if you boil it down to it, I couldn't care less about minor squabbles. Is at the end of the day, we've got to get down to the basics and think about how the country's run.
Well, you only have to analyse what you see on the BBC. You know, every day we're talking about obesity, we're talking about bullying. We're not actually talking about the news as such, are we?
No. You won't do that. This is you mentioned just now things like obesity and that. No, fine, further great topics. This is, but at the end of the day, it's not something that's crucial to the existence of the country and the way we live our lives. They're basically putting on things, programs about this, which are ridiculous. They're not addressing serious issues, and the people are getting wrapped up in dealing with minor issues. But the thing is, programs come out one after the other addressing these simple things.
John, have you talking about really major issues? How are you aware about the rollout of 5G?
Yes, I've got a basic understanding of it, but I haven't been too involved in it. No, I still got a basic. There's certain things. This is when we actually deal with issues just now. You've got the 5G. You've got things like you mentioned in the earlier talk, the situation regarding the EU and the armed forces. You've got various other things. This is what people go on about now. People speak about Agenda 21. I have a basic understanding about these. I certainly don't profess to be knowledgeable in these things, but at the end of the day, I think when I've actually looked at, if you come down to the basic principles, first principles, when you obviously have to live, you've got to protect yourself, protect your family, and you look to the basic standards. Now, when there's a problem there, I could not care less about what they propose to do about various other issues. I'm dealing with urgent things here which affect everyday life for myself, for my family, and similarly, I would think for every other individual in the country. You get back to basics and put the basic principles, the foundation stones in place. And I think there's too much time spent on things like obesity, stupid programs, as minor issues. They are all relevant. Obesity is a huge one. But the point being is, there's too much time spent on this and you're neglecting the basic principles, the foundation stones, so to speak, as to how you operate and live.
So basically, the basic principles, you've got them on a common law courts Great Britain and International website? help to reclaim our rights and lawful remedy. And do you have a CLC card? Now, I've been noticing on Facebook quite recently that people are promoting a CLC card. Would you like to explain? Because I actually don't know what one is. And perhaps many of the people in the audience have never heard of a CLC card. Could you explain what it is, please?
Yes, CLC stands for Common Law Court. And the Common Law Court card is a card that just confirms your position under common law. Having set up or convened the first Common Law Court, members of the public actually came and said, look, we need to use this. We need to use this for various reasons, predominantly being a lawful remedy. Since then, people have turned around and said, look, can we do various things? Now, it started off with mothers, believe it or not, had wanted to protect their children.
So can I just say, on the card, does it actually have like a series of instructions on there?
The card basically gives the basic information about the individual. For example, your viewers may not understand, but I have a name under common law, and it's normally attached to, or the government attach it to, what they call a legal fiction. It's also predominantly been called a straw man in the past. Literally, when people are born, your parents are informed that they have an obligation to record your birth. Now, 99% of the people do, and you're even threatened if you don't, you'll be fined as well. So most people record or register their child. But what they don't tell you about is that when that's done, the state then create what they call a legal fiction, a legal identity. And with that, they then conduct business throughout your life with the legal fiction.
I've got to admit, John, I think I only learnt about legal fiction a year ago, and I guess most of my audience have never come across legal fiction.
Yeah.
So this is where you've got a birth certificate, it's got a number on your birth certificate, your name is written in capital letters, is that right?
Tends to be, yes.
And basically the government trades your life, effectively, on the stock exchange.
Effectively, that's what it's very difficult to try and establish or get to the bottom of it, but basically, seemingly that seems to be the case. It's been attached to various trusts, but what we've done with the Common Law Court, we know it exists. You only need to look at your driving licence or your bank card, that's in capital letters. Effectively, what they do is when they deal with an individual, they attach a legal fiction to it. When you go into, say, a statutory court, if you're unfortunate enough you have to go into a statutory court, they will not actually speak to you as a man or a woman, believe it or not. So if you go in and say you introduce yourself as a man or a woman, they're not interested. All they want you to do is accept the legal fiction. So in my case, it would be Mr. John Smith. Now, if you consent to that and accept it, you're then hooked. You're in their system, their rules apply, and you're bound by them. That's it, end of story. Now, with that, what we've done is we've said, no, that's not correct, because basically you do have a right as an individual man or a woman to protect yourself. And if you've suffered a wrong, you have a right to a lawful remedy. Unfortunately, the statutory system or judicial system is not set up for justice. It's set up for profit, and they basically use your legal fiction to suit themselves.
So, John, can I just interrupt you there? I mean, I mentioned in the previous show that I'd signed my Article 61 oath, and you'd also done the same. Would it be a good idea for everybody watching this show now to sign their Article 61 oath?
Again, this is it. I would probably say there's nothing wrong with it. Yes, it's okay, because it's confirming your position in relation to the behaviour of the government, and the fact that you stand with the Barons and say, yes, we agree with that, which is fine. Unfortunately, within the statutory system, what has been proven to be the case is that despite the Barons signing up under Article 61 and presenting the relevant paperwork to the authorities, they've been ignored. Now, I know very many people who have went in because they've signed up under Article 61 and the right to rebel. They basically went in to defend themselves, and the statutory courts and every other authority dismisses it. So therefore, it doesn't matter whether you stand or not. It achieves nothing. Now, many people have been dealing with this for years, are aware of that. What we've actually found out by adopting and using a stance under common law with the Common Law Court, what we've found out now that in over 100 documents going out to the authorities throughout the UK now, We're speaking about the police forces in England and Scotland that we know of. It's went out to the courts at every level throughout the UK, right up to Scotland, including the Court of Session, in England, the Supreme Court, and in England, the Lord Chief Justice, and even the Cabinet Minister for Justice in Downing Street. They've all had copies of the documents from the Common Law Court, and not one of them has ever been disputed. So therefore, the lawful documents issued by a people's court in the authority of the people, so nobody can dispute them. So it gives you the authority. So therefore, when we've taken these documents and we've actually went into a statutory court, for the first time ever that we know of, we've actually had a sheriff in Scotland confirming that you had no jurisdiction over us when we stood under common law as a man, only on the production of a common law certificate. Because if you go in and you state your name and that you stand under common law, they just ignore you. And it's happened myself included. However, once I obtained a copy of the birth certificate from the Common Law Court, you're then facing them, or you're putting them in a position whereby they then have to rule against the people and against the Common Law Court, because it's a valid Common Law Court document. So they don't do that. And as such, we've had a sheriff or a judge turn around and say, no, we don't have any authority over you.
So is this all laid out on your website, John?
Most of the stuff is laid out there, yes. There is an explanation that goes through the various certificates you can apply for. There's an explanation there. There's one or two videos, but most of the information is available there. We found out just now, this is because of what the people want. The site is being developed as we speak. As I said, the birth certificate was created for predominantly mothers, because mothers had turned around and stated, look, this is fine, we wish to record our birth and we wish to record our child's birth. But because the state effectively take control of the children through the birth certificate, the statutory one, they wanted protection under common law, so then the mothers had asked for a common law birth certificate. Now, this is not a company, it's not a business. Basically, it's a process that exists. So when people say, look, we need a birth certificate, what we've had to do is say, right, okay, we need to do something about it. So we put together something with obviously the people who tell me, they say, look, we can do it this way. So we've decided we will issue common law birth certificates, and they're actually stamped by the court with a seal. So we do that and seal them, it's sent off. So they're quite good, but basically all we do is we cover the cost. So basically there's no profit in it, it's just cost. They're sent off recorded delivery by first class, and they're sent off. So they're actually quite good and impressive, and even the statutory authorities and the clerks of the court have been impressed with them. So it's done at cost, but when people do that, they have that privilege if they want to obtain one. There is no cost involved, however, if they wish to register with the Common Law Court, because what it comes down to is it's not monetary, it's about protection. If someone wanted to stand under common law, it's just to do so, if you think about it, you need to confirm that you exist. The only record of your existence is in the statutory system with a statutory birth certificate.
Yeah.
And the statutory system have you, so you're under their rules. If you want to stand under common law, you can try and claim that anywhere in a court. They won't accept it because you have nothing to back you up. You're an individual. If you obtain a common law birth certificate, you now stand with the backing of a people's common law court and the authority of the people, and judges now cannot do anything about it. Even the Lord Chief Justice in England, they had the documentation that was sent to him regarding this. They had it for weeks, and the Cabinet Minister in Downing Street. They had it for about 9 weeks, couldn't deal with it, and they sent it back saying, we don't want to accept your documents here, we're returning them. They didn't even refer to them by name. When we've actually been in the courts, the statutory courts in this country, none of the judges anywhere will actually refer to the documents by name or address them. We even had one judge trying to defend his position by stating that when the paperwork was submitted in defence of the individual, he had submitted documents which were unacceptable. They seemed to be downloaded from an internet site. Now, that tells you how wonderful our justice system is, because the judge is either thick as two planks or stupid, or he's blatantly lying to protect himself. The reason being is, up until now, I do not know of any printer they would print out a document which has an embossed seal stamped on it from a common law court. So they must have some sort of printing machines in the judicial system if they printed documents like that. He says, so to use that in a defence to justify his unlawful judgment is ludicrous. But basically that's how it works. We've got people just now, because of the documents, we went on from there. We have people just now currently using this in 31 different countries throughout the world, recording their births. Now with that, people have turned around and said, well, what can we do? Can we do something about the legal fiction? So there's a category on there to deal with that. One thing is developed from another, and then people have said, look, these documents are great, but they're A4 documents. We do not carry them about with us. Basically, they're A4 documents. Can we not get anything that we can put into a wallet or a purse? So we sat and spoke about it with various people and said, look, there is an option, we can do cards. So people had decided, yes, okay, we want to do that, but obviously there's more cost involved in the machine. We said, look, we need to do something for this. We'll have to charge for them. So people had agreed to do that. So we charged for that, and now people get common law court cards. Now the common law court card does a couple of things. First of all, it's issued by the common law court, so it's a lawful document. It's actually protected, security protection on it as well, so it can't be copied. There is a passport photo on it of the individual, and then there would be your common law name. Now, my common law name is just John Smith. Now, what I've done is with that, I've recorded that with the common law court. Having done that, I've obtained a reference number. So when I produce the card, it has my common law name and the reference number. So that lets everyone know that I've recorded my birth under common law and that I stand there and I have the record for it. Beneath that, it then gives you the legal fiction. Now, the legal fiction for me would be Mr. John Smith, and it's all capital letters. Now, what I've done with the common law court is I've obtained ownership of the legal fiction. So what I've been issued with is a reference number from the common law court, and that confirms that I lawfully obtain ownership of the legal fiction. It then has a date of birth, and then because there's various categories you can register with the common law court, they're all numbered. So basically we display the numbers for the categories that you have registered with. On the flip side of the card, there's a QR code in the back, so if someone wanted to scan it, it would send you straight to the website, and there's contact details for the website, which is the website address and an email address.
John, can I just interrupt? Somebody is putting up on the chat.
Yeah.
It won't work in England. Why won't it work in England?
It does work in England, so why won't it work in England?
Well, it says Scotland has different law with additions that England does.
Right,
Now,
okay.
I know people who have taken themselves out of the system in England, and they don't even pay any bills anymore.
Yeah.
Have you come across people where they've actually they've called themselves another name, and basically they get their food paid, their energy bills paid?
There are various people who do different things. They come out of the system, some have come out completely. The point is, we're not actually suggesting that people are coming out of the system. Bear in mind, if you record something under common law, there's no cost, this is for recording your birth. So you go online, you submit your information, that's it. The only thing doing this helps with is to protect individuals. So basically, if you suffer a wrong, you have an access to a lawful remedy, because the existing system is failing. However, in your everyday life, you still pay into the system, you still pay taxes, you're still part of the community, so therefore in your everyday life, you just continue as normal. Now, when we get back to the viewer's question just now, which is, it's nice to know that people are asking these questions.
Yeah.
However,
even if he is called the helpful troll.
Yeah, Paul, even when you look at this situation just now, it's brought up a previous point we discussed. It says that the laws in Scotland are different from the laws in England. Okay, yeah, fine, I'll accept that.
Yeah.
But to a degree, no, I won't, because what you're exactly discussing is statutory laws. Statutory laws are not, in fact, laws. The statutory system, basically, they produce what they call statutes and acts of parliament. It says they only become law if the individual members of the public accept them. If they don't accept them, they're not law. They're rules for the statutory system. The only true law in this country is common law.
And that's what unites us.
Yeah, and that's it. So
North
therefore,
and south of the border.
Common law in Scotland and common law in England is exactly the same. It's common law.
That's right.
It's down to basic principles. Everything else that they're disputing, or the differences between the countries, is what the state have created.
Now, I know Ken Dewdney. He's in France. Have you met Ken Dewdney at all?
I haven't. I've read his book.
He focuses very much on the trial by jury system and where the jurors actually vet the laws and say whether it's appropriate before they try an individual. Is that what happens under your court system?
Well, basically under the court system, it goes back to basic principles. The court decision, the laws are made and created by the people. So basically it says within that you have 12 jury members. The 12 jury members have the authority to find obviously someone guilty or not guilty, but if they find them guilty, they then can actually put in various punishments, sentences. They have no discretion whatsoever. They can basically deal with it as they seem suitable. Now, what we've said is we've had a common law court convened before, which I actually went to watch. I played no involvement in it. It wasn't my case, but I went to watch. And it was apparent afterwards that there was bickering between the jury. Now, bickering, it was harmless banter. But I don't think the issue of the judgment was ever in question. I think because the jury members take it very, very seriously, what we found out is that they're taking a very, very long time to deliberate. And I think from what limited knowledge we have, I think that the reason for the lengthy deliberation is because they are trying to reach a fair and honest judgment. So they're not actually holding people accountable for the crimes of the state. Someone is being summoned to appear in a court for a specific reason, and they're being tagged or addressed for that reason alone. And when they've got to think about any punishment or sentence, they then deal with it appropriately.
Well, we've still got the helpful troll still trolling, questioning about the Magna Carta. He says, watch Magna Carta by David Starkey to realise why the Magna Carta is not applicable in England. But I think we covered this at the beginning of the show anyway. We didn't actually say the Magna Carta, did we? We said we'd moved on from there, hadn't we? Because it was protecting the barons as much as the people.
Yeah.
So need to listen to the beginning of the show there. Somebody's mentioned about Sharia law courts. Well, that's in 85. I think there's 85 Sharia law courts, isn't there?
Yeah.
They're not supposed to be valid in this country, but apparently they seem to be behind closed doors and things seem to be happening. But what does the government do about it?
I think as far as I'm aware with the Sharia courts just now, is something that we can't actually stop. It's something that exists and it's used. And I think my understanding of the government just now have came to a sort of an acceptance that they exist. And I think they're trying to work with the communities to try and see if they can sort of make sure that they're done on sort of favourable grounds for the individuals concerned. And basically they're run reasonably well and they're not too extremist. So I think the government certainly can't stop them, but they want to try and obviously make sure that they're sort of acceptable within our community. Now, the other issue is which is something similar. If you get back to it and you think about the basic principles, it's similar to common law courts. Common law courts are set up by the people, and it's to obtain a lawful remedy. But the government or anyone that says the authorities have no right, have no authority to interfere in this process. And technically, decisions issued by a common law court are far superior to that in the statutory courts. But the statutory courts are companies run for profit, and decisions issued by a common law court combines with it the authority of the people. So they're far superior. Now, I'm aware...
Well, can I just interrupt you, John? Because I think the helpful troll saying it's nonsense. He didn't hear part one where we said that common law courts have been running now for a couple of years and remedies are now being issued. So perhaps the helpful troll could watch episode 1 and yes, they are working. Thank you. John, I can't hear you.
Speak.
Sorry.
Right, so
I'm
John,
sorry.
so in part one, we did say that you started off with a common law court last year. Was it in Ascot?
No, the one we started with was in Dunblane in Scotland.
Dunblane. But you've been doing some in England as well now.
Yes, the latest one was in Ascot, down beside Glastonbury. There was 5 individuals. Again, this is people from England convened a court hearing for themselves to deal with 5 issues, separate issues. It involved sending out summonses to 6 individuals who were found guilty by the jury members, and various sentences were actually issued, which we're in the process just now of obviously enforcing. So the relevant court orders have went out to the individuals concerned, and we're waiting to see if they're going to reply to it before moving forward.
Right then, John. So to summarise, you've got a working website, you've got all the instructions on there, you've mentioned about convening common law courts, you've said you put posters up. Have you got a standard poster on the website at all?
No, there's information on the website. We don't. We address various issues, and when information is available, we'll put it up by way of a news bulletin or a breaking news option. When there's any meetings or anything coming up, we will put information available, but we don't have standard things to issue. Although similarly, people are actually asking for things within the site to say, look, we'd like to promote this, we'd like to have T-shirts, we'd like to do various things and put on logos and things and get hearings. These are all commercial things. It's not about commerce, it's not about making money. It's basically it's a process for people to use. It's free at source, and that's the way it remains. But obviously people have been asking for additional information. With the limited resources we have just now, we are obviously getting the information out there, and people are actually learning more about it as we go along.
I think you're going to be inundated after this show with people contacting you, I reckon.
Possibly. Every time, I don't know if it's quite good, we actually had a guy I know in Scotland who deals with common law issues here, was actually invited, because he has a YouTube channel, he was invited to speak up about common law to a company in America. They actually do a podcast thing, and also it's on the radio station. Now, they had asked him yesterday about something he's done, I think he's going out on Thursday, but they spoke to him about the common law court. He had a basic understanding about it, and the guy on Thursday said, well, look, when this goes out here, it's a big thing in America, you're probably going to be flooded with that. So unfortunately, it's just something we've got to deal with just now, but so we do have additional people that can help out if need be. So obviously there is a limited crew just now helping to do this, but as it expands, we will have to think about obviously getting more people involved.
So basically you're looking for volunteers, and you're looking for lots more interest from people throughout Scotland, England, Wales, Northern Ireland.
Yes, everywhere.
Yeah, everywhere. Part of the United Kingdom, so that we unite under common law.
Yep.
Well, thank you so much, John. It's been interesting talking to you on part 2 of A Lawful Remedy. People can contact you via www.commonlawcourt.com. And
Yes.
once again, thank you, John, for being on the show today.
Okay, thank you. Good night to yours.
Thank you. Goodbye.
Bye-bye.
Bye to everybody as well at home. Thank you.